quorum. Well, thank you for being here this morning. This is the Joint Committee of the State Tribal Relations. And this morning we have one item on our agenda, and I'd like to turn it over to the Office of the Governor, Justin Whitman, and give us your version of what we're doing here. Wherever you want, comfortable.
Good morning. Thank you, Mr. Chair. My name is Justin Whitten. I'm Governor Kelly's Chief Counsel and her designee on the Joint Committee on State Tribal Relations. Just as some brief background on why we're here, Senate Bill 84 that was passed by the legislature last year authorized sports wagering in Kansas. There was also a provision that provided if the tribes requested and made a request to the governor, they could reopen the gaming compacts. The gaming compacts are what an agreement between the state and the tribe for authorized gaming on the reservation on the Indian lands. Prairie Band Potawatomi Nation last year, sometime in June or July, made that request to the governor's office. And since that time, the governor's office and the tribe and tribes council have been engaged in revising the gaming compact. I believe the last time it was revised or even enacted was 1995, so it's been some time. And the parties have been negotiating since that time. Just to let you all know what the tenor of the negotiations are. I believe both parties negotiated in good faith. We went through this with a fine-tooth comb and have wrestled with some important legal issues, but I believe overall it is in a good spot. So with that, Chairman, I'll stand for any questions this body might have.
Are there any questions? Yes. Senator Holland.
Thank you, Mr. Chairman. Sir, thank you for being here this morning. Just a quick question for you. My question would be, sorry. Well, that's okay. My question would be this is that I'm assuming that what has been negotiated in this compact with the Potawatomi Nations, I assume that is consistent with the expectations of the commercial gaming interests with Senate Bill 84. Are you anticipating it's all in harmony? Do you see any kerfuffles potentially between the commercial gaming folks that were granted the sports wagering capabilities through Senate Bill 84? Do you see there being any disconnects, their perception of this versus what has been negotiated between the governor and the tribe?
Thank you, Senator, for that question. I don't know if I can speculate as to what they might bring in terms of any legal actions or kerfuffles. I can say that the way we've negotiated this compact was to look at compliance with IGRA, Indian Gaming Regulatory Act, Senate Bill 84, and then subsequent legislation. The name of the bill that was passed this session is escaping me at the moment, but I can certainly find that for you. So I think I can represent that we believe that this is compliant with the law. We can't always say, somebody might sue for any reason, whether or not it's meritorious. I think I can represent, I believe we've negotiated the compact in a good and defensible position.
And you're not aware of any potential discrepancies or anything at this point?
I'm not aware of anything that somebody's going to come and say, this is completely wrong and we're going to sue. I mean, there might be grumblings. I just don't know who could come out of the woodwork to bring suit.
Understood. Thank you so much. Thank you, Mr. Chairman.
Senator Haley.
And thank you, Mr. Chair, and thank you for the overview that's here. I'm be completely transparent. We really don't have much other than what you've negotiated that we can do from this standpoint, except to approve, which hopefully we will, and disapprove. My question was more one of, during the course of negotiation or discussion, did we look at some of the existing elements that are state-owned and other gaming entities are heir to, some of the ancillary, and these are my concerns, like the problem gaming issues or others that would mirror, if you will, other terms that would mirror what we already require of state-owned, just by way of, not that we can affect the policy, but that we can hopefully have some interaction that may be of some actual benefit to the state as well as the nations that will be implementing this.
Thank you for that question, Senator. So to address one part of your question that I heard about addressing any elements of problem gaming or benefits to the state, I can say that we did look at the negotiations, and as this has been a bit of a trial by fire for myself in terms of learning the complicated framework for Indian gaming as it relates to what's also permitted under the state lottery contracts or what's authorized by the state. But under the regimen for the gaming compacts, there is an oversight body, the Kansas State Gaming Agency, and we did work with them to kind of look through the provisions of the compact. And as you'll see in the amendment, one thing that we've done to address like in concerns about any what we call the moral hazards that might exist within gaming is the tribe has agreed to adopt, I believe it's Appendix E, is that right, Bess? Appendix E to speak to some things like the tribe will look at promulgating regulations through the Kansas, through the Tribal Gaming Council, things like no betting on sporting events where the majority of the participants are under the age of 18, because we don't want people gaming on, say, high school games because of the moral hazard that might exist there. So in that regards, we were cognizant of, how will this be regulated, and also mindful of the fact that the tribe does operate as a separate sovereign. So it was kind of a lot of moving parts. We worked with Kansas State Gaming Agency, worked with the tribe and the tribal's council so that they could tell us how the Tribal Gaming Commission worked. And hopefully I'm addressing your question.
You are. And, Mr. Chair, and by way of follow-up then, beyond problem gaming, would there be any other, and I'm sorry I haven't read the amendment, but anything else that might put on a closer even footing by that which we require, the state requires of our state casinos, that we are asking, because that's all we can do is ask, for this compact to mirror? You mentioned problem gaming. Are there any other areas where we might have some, at least a discussion or dialogue, at least to throw it out there, if you will, to see if the nations will adopt or be a part of beyond problem gaming?
Yeah, well, if I'm understanding your question correctly, it's really like, it's a question of, do we have parity in how we're regulating sports wagering under how the tribes will regulate it versus how it might be regulated through the state-owned and operated lotteries?
You have better articulated my question, yes.
Thank you. So I do think that was always a tenor throughout our negotiations is when the tribe came to the table requesting that we reopen the compact, we wanted to try to put everybody on the even footing that you discuss and make sure, are we regulating it in a comparable way? It's a bit tricky, and this is based on my understanding. Prairie Bands Council can elaborate on this further, but because they are a sovereign nation, there are questions of, what's permissible regulatory authority. That being said, they do have their Tribal Gaming Council, and we can build into the compact certain regulatory agreements or that they will abide by. So, you'll look at the amendment has provisions for defining sports wagering and sporting event. We talk about remote sports wagers, and the whole purpose of drafting those definitions and providing the permissibility of sports wagering was to try to put the tribe on even footing because, as I understand it, the state-owned and operated lotteries are up and running with sports wagering. Right now, Prairie Band Potawatomi Nation is not, because the compact actually, when it was drafted in 1995, has an express prohibition against sports betting. So for us to even begin, we need to strike out that sports betting prohibition, and that was one of the amendments. I want to make sure I'm answering your question.
Somewhat, pretty much you have, and I appreciate it. Thank you, and thank you, Mr. Chair.
Thank you, Mr. Chair. I appreciate it. So I'm a Johnny-come-lately to this, but I've always had some questions about this. Can you tell me what did not get into the compact that was requested by the Tribal Council or the Prairie Band?
Thank you for that question, Senator Representative. If you give me 1 minute to think, I want to make sure. Russ, am I allowed to share what we discussed during our settlement negotiations? Yeah, okay. Well, we had conversations with the tribe. For one example of things is looking at geographic boundaries. We decided that that was a much more complicated issue of what is the Prairie Band Potawatomi Nation's true geographic boundaries, because the tribe's reservation, I don't intend to speak for them, but from a legal perspective, as I understand it, that's a question that's really decided by what was the tribe's agreement with Congress, because it's Congress's purview to set, treaties with the tribe. So there was a discussion during our compact negotiations of, what is the true boundaries of maybe the Indian lands. We tabled that for the purposes of this compact because that was just going to be too much of a thorny legal question.
Can I stop you for a minute only because I'm an old guy, I can't process this quick. So you stopped that not because there was a potential liability, it was because of procedures that needed to be followed in order to expand that area. Is that what you're telling me?
And legal research. It's a question that for us to settle it and settle it authoritatively would require a lot more effort. And we knew that we were working on a bit of a truncated timeline because we wanted to get it to you all so that you could review and potentially approve it for this, hopefully approve it for this session. And where we were in the negotiations at that time, we thought we're just not going to be able to solve it. So if you want to call that process and procedures, we can say that I think it was really also a resource bandwidth issue.
So legal research, does that mean case law?
Case law and figuring out who's going to decide that question authoritatively. Is this something that would be ripe for an AG opinion, or is that really something we need to go to the U.S. Department of the Interior Bureau of Indian Affairs and ask them to weigh in?
The tribe wanted that. We didn't want to put the time in and try to do that because we felt rushed.
Well, I wouldn't say we felt rushed on the part of the tribe. I think it's a question that they brought up, and we're still willing to have those conversations. I think both parties, as we were talking about it at the table, and like I mentioned earlier, I do think we were negotiating in good faith. I think both parties looked at it and said, we have some other legal questions, and for us to get this across the finish line, can we agree to table this?
So what's been added to the compact, this one, from the last one, that the tribes have requested?
Well, sports wagering is one, and that's what's now permissible by Senate Bill 84. So under this compact, the tribes will be allowed to accept sports wagers on their Indian lands. And then a little bit more of a nuanced permissibility is something called remote sports wagering, which is a concept where if you are not on the tribe's Indian lands, but you're within the state of Kansas, and as long as you're not on another tribe's Indian lands, you could place a remote sports wager through a server that's located on the tribe's Indian lands, and that would be considered a gaming compact bet. Now, that's still an open question, and we have tied that to waiting for a permissible decision from certain courts.
Mr. Chairman, a couple more questions, please. So what other issue that they wanted in the compact that did not get in here?
And another issue besides that one?
Well, that was one. Was
That's one.
there something else that they wanted in the compact?
Well, I guess I didn't answer your question correctly, because that's something that they wanted in the compact, and I feel like that is in the compact. Other things that were...
I really am interrupting because I do have a short moment.
sure.
So they wanted it in the compact. You feel it is in the compact. So is it in the compact?
Yes, what I just spoke about with the remote sports wagering, that is in the
They were
compact.
satisfied with that.
I believe so. I believe that's a negotiated agreement. Other things that... Gee, Russ, Yeah, and if you all would like to hear from Chief of Staff Will Lawrence, I'm sure he's able to speak.
Have the answers?
Well, I looked at Russ because he was across the table at the negotiating, and I feel like everything else that I've covered really, it was just the Indian Lands Reservation boundary, and the other points that the tribe brought to the table, I feel like we were thoughtful, we considered them, and we were able to incorporate them where appropriate.
Fully?
Well, I mean, partially. I mean, we were able to do, it was negotiated, so they might come to the table and we might ask for some tweaks. I wouldn't say we were able to accept everything wholesale, but everything was accepted and negotiated. Not everything was accepted, but a lot was accepted and negotiated in good faith.
And the reason I ask these questions is because I have followed this process, not in detail, but over the years. I've been here since 2012, and I've always felt that the tribes are pretty passionate, but I also feel that they're a group of people that do not want any problems, but I also feel that they have requests that need to be fulfilled, and it's always the answer that I just heard: we're rushing, we didn't have enough time, potential for litigation, et cetera, et cetera. And so I've always felt that's a good way to, if you're on the other side of the negotiating table, to pacify a group of people just to get them satisfied, give them a bone and let them be happy till the next renewal. So I don't really consider it, I consider it negotiation, but I consider it disadvantaged negotiation. And I understand that we got to be careful what we do legally and for repercussions. That's why I asked, was there case law on some of these issues that you referred to, or was it just interpretation of what potentially could happen? And I always question that interpretation because I may ask you, and the answer may be totally different. So, well, thank you for your answers.
Yeah, and Mr. Chair, if I may, I want to say that when we begin, the tribe came to the table and they had some proposed amendments right out of the gate when they brought their letter requesting the compact be opened. And that was very helpful because it gave us a starting point. And that was back in June or July. So I don't feel like either party was set up or rushed or, sort of threatened with a stick of like pending litigation. I think because it's areas of the law that are not well settled, there's always a potential threat of some litigation that we can't foresee. But we've worked through the issues, mitigated risk to the best extent that we can. And what I hope to communicate is that since July of last year, we've had good, reasoned negotiations with the tribe. And, I don't know if I would call it rushed.
Could you, just a moment, sir. Could you give us a timeline on when the bill was completed last year, and then your timeline on the negotiations, so that give us a little idea what you're looking at?
Yeah, so Will would know better than I as to when the bill was passed last year. But, so, Mr. Chairman, if it's all right, I'll have Will Lawrence, Chief of Staff, answer some of these questions on the timeline. Thank you.
Thank you, Mr. Chairman. Will Lawrence, Governor's Chief of Staff. I would tell you that this has not been a rush process at all. It feels like it right now because of where we're at in this session. But because Symbol 84 became law last year, I can't remember the exact date, but over last summer, we began sitting down and negotiating under the content of Symbol 84 for this compact. And so it has been an ongoing process. I think that both sides have wanted things in the compact that neither got, or we got some compromise on the language. I do think that Prairie Band wanted to have the ability to accept wagers across the entire state of Kansas outside of tribal lands now. We couldn't agree to that. We had a lot of conversations with the Attorney General's office, who advised us there was great legal risk in that from their perspective for the state of Kansas. And so that's where we landed with the language saying that it cannot be done unless it is expressly authorized by the D.C. Circuit Court of Appeals, the 10th Circuit, or the United States Supreme Court, because there is a case pending out of Florida, the Flagler case, that may dispose of that issue. And if that issue is decided in favor of the tribe's view, then that's federal law, and it's done. There's nothing we can do. I think it's important that the compact speaks only to sports wagering. There is another thing on the horizon that people are starting to talk about in terms of iCasino that is not allowed under state law. We don't want that to be a conversation under the compact right now. That's something that has to be decided by the legislature first. This allows us to stay focused on just sports wagering and not going into these other areas. And so I think this is certainly a good negotiated agreement for both sides. That I think we spent a lot of time discussing the issues, and it led to needing to pass a bill to deal with some of this because the landscape and federal law is and maybe will continue to change on this issue. So those are a couple pieces that I would highlight in relation to this.
Thank you very much.
Yeah.
Yes, sir.
How you doing, Will? So it wasn't my perception that I said it was rushed. It was the statement that was made. The statement that was made was they wanted to look at territorial boundaries. Mm-hmm. And he said because of time sensitivity, and he went through the litany of the process, and we wanted to hurry up and get it to you here. Mm-hmm. To me, that's kind of always been the problem, is that we're always in a hurry to get it here. But does that mean now, do we just drop that, or do we start moving forward to try to look in the next compact to look at what they're requesting for territorial boundaries or whatever that may be? So he was the one that said they were rushed, not me. And my question is, we shouldn't be rushed. I think it's a rushed process because we do the negotiation for the compact, then you get elected officials together, 2 meetings, bam, bam, and then we're out of here, and nobody questions why and what. I'm not saying nobody, maybe somebody does. But, so here's my concern, is that in these negotiations, the tribal should have the leverage to negotiate, and we should try to make everything possible fit in within that negotiation, because we're talking about, and I mean this isn't a bunch of political crap, indigenous people, their land, and so there needs to be some type of agreement that gives them the edge to allow them to do what they do within the casino boundaries. That's my concern. Nobody ever brings this up or asks these questions because, at least as I've been monitoring this over the last few years, it's in and out. Of course, there's different people here all the time, but I think we need to start looking at, and I would suggest that we start moving forward on looking at some of those boundaries and territorial lands and see if they can be changed or if we can put something in motion to do them, and anybody can be sued. Sometimes you've got to take that risk, and nobody will get sued. I mean, it's all based off of interpretation, and that's why I bring that up.
Sure.
Thank you, Will. Thank you, Mr. Chairman.
Representative Alco, and I want to be clear, I'm not trying to put words in your mouth that you were calling it rushed. I just want to make sure everyone knew that from our perspective, we don't feel like it's rushed. I understand the feeling right now. Part of the challenge is that the compact has to be ratified by the legislature before it can even go to the feds for review and approval. And so there's that process we're trying to be mindful of, and Prairie Band wants to get this going because they're a year behind the state-owned and operated casinos. And I also think that some of the issues on the 30 by 30 land versus the 11 by 11 is also a conversation that I'm not entirely sure has to be within the confines of the compact. That's part of it, but this may be a separate federal discussion. So I don't think this precludes those discussions or other discussions. But I also know that Prairie Band was very clear when they requested to negotiate the compact. They didn't want to open up the entire compact. They wanted to keep it narrow and focused on sports wagering to get it done because they wanted to be able to move quickly on that. So that's why this is so constrained to sports wagering and not looking at other issues. I mean, we did deal with like the alcohol issue, which has been an ongoing limitation for them. So we tried to address some of those minor things that makes this easier for them, but we really tried to focus in on sports wagering.
And, Mr. Chairman, yeah, again, I got that rush impression from the previous speaker. And don't always try to get the last word in on me because I am going to get the last word in. So don't say nothing after I'm done so I don't have to continue talking. But I totally understand what you're saying, but my issue is don't let it drop. And if I'm the tribes, I'm going to be afraid to open up that contract for fear for what I might lose instead of for what I may gain. And so, in not knowing where everybody sits during negotiations, and I'm sure the governor's visited with them and told them, hey, we can do this, we can do that. But for many years, they've been told that by all governors, and I think the waiting game should be over. And I think there shouldn't be any risk of losing something in that compact for trying to get something that they want. Thank you, Will.
Any other questions? Yes. Representative Hayworth.
Thank you, Mr. Chair. So why did this take so long? Like you said, the previous sports betting went into law July 1st. Now the tribes had a disadvantage from the get-go. Why did this take so long with negotiations? And why are we seeing this only, I think tomorrow, the legislature's trying to get out of here. Why are we seeing this so short of a deadline?
Thank you, Representative Hasswood. So I think it's a fair question. We started last summer, and of course, Symbol 84 has two components to it. One is the tribal compact, and then a separate language that directs the tribes, once they've requested to negotiate the compact, to the lottery to get a same or similar contract as the state-owned and operated casinos. And so we spent a lot of time trying to figure out how to make that work. And one of the challenges of that is that you're asking a sovereign nation to have to essentially create an LLC or some sort of other structure to waive some level of sovereign immunity, because in order to have a license through the lottery, the state has to own the gaming facility or the operations, right? So Prairie Band would have to then say, we're allowing the state of Kansas to own our sports wagering operation for anything outside the boundaries of the tribal lands. And so that obviously was very complicated, and there were some delays in, frankly, the contracts that were offered to the casinos were not quite as timely in getting to Prairie Band. And so we spent time getting that information to them and having them also weigh in on the regulations that we were trying to adopt to get sports wagering moving. So because of the implementation time of sports wagering and also learning how the state was going to regulate it, also slowed everything else down. And then, of course, things went into the fall, and now we're here.
Thank you. And one more, Mr. Chair. Okay. So does this compact, is it just for Prairie Band Potawatomi Nation or the 3 other tribes of Kansas?
This is for Prairie Band Potawatomi Nation. So Iowa has requested to negotiate a compact as well. The others have not yet. So there will be 4 separate ones ultimately dealing with this issue if each of them requested.
Okay, thank you.
Any other questions? Representative Carpenter.
Thank you, Mr. Chair. So you opened kind of the can of worms that I was questioning. So where does it intersect with the current gaming that we have with the casinos? Is it under the same percentages? Is that all negotiated, or is there some, in here, is there some of the percentages and some of that stuff that we already have with the other casinos?
Thank you, Mr. Chairman and Representative Carpenter. So the answer is no. Under Symbol 84, the reason there were 2 different components was I would certainly contend, although I didn't write Symbol 84, but the compact language was the compact would be as it currently exists. And right now, the current compact does not have any revenue share for the state in terms of the gaming aspect. Prairie Band does provide some funding to the state gaming agency. There's a process for budgeting to fund that agency that oversees them. And oversight is probably not the right word. I know I'm going to get myself in trouble for saying that, but interacts with them on some of the regulations and stuff like that. So there's that process. But I don't believe that Symbol 84 anticipated a revenue share within the compact. It anticipated a revenue share within the contract with the lottery for any statewide operations outside of the tribal lands. So right now, the posture is federal law could change that. And if federal law says that a wager accepted on tribal lands is deemed to be a compact wager, then we really can't force them into a contract with the lottery. Conversely, if the decision comes down that the hub and spoke model is not allowed and that a wager is deemed placed at the location that the person is when they place it, then Prairie Band is going to have to consider their options to go under the lottery, which would be a same or similar termed contract. So this is where the federal law, state law, and the fact that Kansas is very unique in that we own the 4 casinos and we own those operations through the state made this discussion fairly complicated. But that's why this is different.
Just a quick follow-up for that. So thank you, Mr. Chairman. So there's no timeline on this one either. Our other contracts are 5 years?
No, correct. There are no timelines on this one.
Okay, very good. Thank you. Thank you, Mr. Chairman.
Representative?
Thank you, Mr. Chair. Will, one last question. So being that the state does own casinos, so does that come into a competitive nature when negotiating this compact to try to keep a limited amount of issues that would be put into it?
So I guess how I would probably answer that question is I think that the state-owned and operated casinos certainly would have liked to have been party to the negotiations and probably would have liked to have had certain things in there. They were not party to the discussions, and we view this as a separate conversation, right? I mean, part of the issue with the casinos having a contract for a certain period of years is that, I mean, there's an RFP process. So at some point in their contracts, either not extended or they run out after the extensions have been granted, we can change them out. Obviously, we don't, that's not the same mechanism with Prairie Band, you know, that we don't have any control over that. So that's why I think there's no length of time there. So they're just very different. And so, no, I don't, you know, we considered some of the issues that, you know, the casinos would raise, but those are not reflected in here in terms of, you know, percentages and stuff like that, or trying to make it equal to the casinos, because they're different.
It's my perception that I'm negotiating with my competitor. It puts me at a disadvantage. Is the playing field look like that?
I'm not going to speak for Prairie Band and how they may feel on that.
I'm asking on the state side.
Yeah.
Because it seems like they have the hammer. And so the Perry Band can negotiate, but it has to be approved by the state. So is the playing field level, or because we have casinos, is it unlevel?
I guess the way I would view it is I'd say it's fairly level. I mean, one aspect is that the casinos do have a revenue share with us, and, you know, Prairie Band does not. So I think that when you counterbalance that with some of the other issues that they maybe don't have that the casinos do have, I think it kind of levels out across the field. That's why there's some differences. But all in all, I do think it's a level playing field.
I would advise against involving the casinos to be part of the negotiation. There is a difference, because those casinos, of course, everything's business, but those casinos are run by the state. This casinos are ran by Native people who have a big culture and who are indigenous to this land, so that should give them the advantage when we sit down at the negotiation table, even with the governor. Thank you, Will.
Thank you, Mr. Chairman. Well, thanks for being here today. My first time on the committee, and I appreciate the technical background you're giving us. I guess, some quick questions. Would you anticipate that the compact that this for sports wagering we're doing here for Prairie Band Potawatomi, for the other nations that subsequently come to the table, would you anticipate that this is pretty much going to be kind of like the model? Would you anticipate any deviations, material deviations from subsequent tribes coming saying, hey, now we're ready to get into this?
Thank you, Mr. Chairman and Senator Holland. So I would say I think this is going to be certainly the roadmap. I don't know that all four compacts are identical, so there could be some tweaks or minor changes, but I do believe that this will kind of be the roadmap and be very similar in terms of the sports wagering and the regulations and those type of things that are adopted here.
Okay. And Mr. Chairman, just one more quick, this is just for technical, my own information. When we basically are talking about policing the state sports wagering, i.e. the commercial interests, the non-tribes, when they're determining basically if that bet can be placed on their app or whatever, I'm assuming it's some sort of IP technology where the server determines if that wager is actually in or out of state boundaries. Is that correct?
Yes. So there's the geofencing that is done. And so like for the state right now, we cannot accept wagers placed on tribal lands through the lottery. So we've geofenced those lands off and geofenced the state boundaries. So they would be doing very similar in their technology to geofence everything off. And then the question becomes under federal law, is the wager deemed placed where is accepted on the server or where the person is?
And Mr. Chair, just real quick, and thank you for your indulgence. Just where I was going with this is that, are we ever going to be in a situation where the tribes have different technology versus the state-owned casinos in the fencing application and who can place a bet and who doesn't? Do you see any issues with that going down the road?
I don't foresee any issues, but obviously you know as well as I do that technology changes very rapidly, and it will change in this environment. So I certainly can't predict what may come on the horizon. But as far as I understand the technology, I don't believe that there will be a difference that provides any advantage to one side or the other.
Thank you so much. Thank you, Mr. Chairman.
We're going to move to Justin.
Thank you, Mr. Chair. I just wanted to mention one thing about the framework under which this was negotiated. I don't think I mentioned it, but the Indian Gaming Regulatory Act does impose on the state a duty to negotiate in good faith. So that's why I was mentioning that earlier. And that good faith requirement is how we kind of looked at the level playing field. So we didn't see our negotiations as ever in a position of saying like, we'll take our position or leave it, but we hold the ultimate say so.
Representative Tidewater?
Thank you, Mr. Chairman. My question was answered.
Senator Haley?
And just to reiterate, thank you, Mr. Chair, the mechanics of this, and I'm sorry, I don't gamble, but this actually works. One need not ever visit physically the casino, but it's basically going to be engineered through an app, an application. Is that correct? Is that how it's implemented? So for a level playing field, anyone can download the app applied to, in this case, Prairie Band or any of the others, and need not ever physically go there. So is that correct? Again, I don't know how it works.
So that's kind of correct. I think what I'd say right now, under this compact and under state law and the framework, if you want to place a wager on any of the state-owned or operated casinos and their applications, correct, you would never have to go into a casino anywhere within the state to place a wager. You could. Several of them now have the ability to go do that in person. For Prairie Band right now, you could go into the casino. I believe that they will have a bricks and mortar operation there. They will have an application that will work within the tribal lands. So technically, yes, if you lived on the reservation, you never went to a casino, you could download their app and do that. If federal law changes under the Flagler case, then you would have a scenario which Kansans could potentially place a wager, in Topeka or Kansas City or Wichita, that is on the tribal lands, and they wouldn't have to go visit there in person.
So briefly, please, Mr. Chair, Mr. Lawrence, Will Lawrence, what are the geographical boundaries that were previously discussed? Why does that matter for the terrain? I mean, if one need not physically be at the casino, what is that? I mean, that goes over my head.
That gets into the whole discussion about the 11 by 11 territory versus the 30 by 30, which is part of a treaty of the early 1800s, I think, and some discussions about that in congressional action. So that's an interplay with federal law. Currently, under previous interpretations that is currently being litigated, federal law does not allow for these wagers to be taken off of Indian lands. So that's where we're at right now with the different language. That may change, but until that changes, this will be the current model that is prohibited unless authorized under federal law. I don't know if that answers your question.
Kind of. Okay, thank you.
Any other questions? Yes.
Mr. Chairman, I'd like to rebuttal to Justin's out of the governor's office comment about a level playing field. That question was asked way back in the dialogue, and Will answered that question. So I always get concerned when somebody brings it up again to try to justify that we did the right thing, and it is a level playing field. I've been in politics 31 years. You can read me the law, but the interpretation and the level playing field is never what it's perceived to be. And I can bet you, I might be wrong, I can bet you the reason we're hearing this today is because somebody from the governor's office told them to submit this late so we can get it knocked out before session is over versus submitting it and getting it done sooner to allow more negotiation time and maybe more political pressure to try to get something accomplished. I may be wrong, and that's my opinion, okay? But I just think that I bet it went that way. I bet if I asked somebody, did they tell you to bring this compact at this time? Because we have 1 week left, and who can raise hell in 3 or 4 days, right? I bet that worked that way. So I don't agree with you, Justin. Thank you, Mr.
Further
Chair.
discussion? Thank you, Will.
Thank you, Mr. Chairman.
Move forward on the agenda, and the next item on the agenda would be a review of possible joint committee actions, and Jason Long with the Revisor's Office. Jason?
Thank you, Mr. Chairman, members of the committee. Now that all the difficult questions have been asked, hopefully my time up here will be brief. You have a memo at your seat on the Joint Committee and the actions that are available to the Joint Committee under the statute, KSA 46-2302. The statute directs this Joint Committee to review any gaming compact or amendment thereto that's proposed and presented by the Governor's office. I will note at the outset, as been mentioned, neither this committee nor the legislature as a whole has the authority to amend directly any provisions of the amendment that's been proposed today. There are 4 actions specified under the statute that the Joint Committee can take. The first one is to essentially refer. Yeah, I'm sorry.
We've just been notified that the House is voting, and so what we're going to do is go at ease for 15 minutes, so we'll be back here about 5 after. Thank you. We're going to have to all say the same thing. voting again. We're going to recess for another 10 minutes. 10:15. Order, and we'll replace where we were. Jason Long, if you'd give us a little possible joint committee actions.
Yes, thank you, Mr. Chairman, members of the committee. As I stated, you do have a memo at your seat on the statutory direction for the Joint Committee. The Joint Committee is directed to review any proposed gaming compacts or amendments thereto that are submitted by the Governor's Office. And as I pointed out, neither this committee nor the legislature has the authority to directly amend those compacts. It's either an up or down approval or rejection of the compact by the legislature. The statute does lay out 4 different actions this joint committee can take with respect to the compact. The first would be to essentially refer it back to the governor's office with recommendations on changes to make. And so you can recommend changes, even though you can't make those changes directly. The governor would take those under consideration and potentially reopen negotiations with the tribe if that's the action the committee takes. The other set of actions involve forwarding the compact to the full body, to the full legislature for a vote on the compact. This basically has 3 different types of actions. The committee can vote to recommend approving the compact, in which case the committee would send would introduce a resolution approving the compact in each chamber, and then the body would vote on that resolution. The committee would also submit a committee report to each chamber, advising chamber that they recommend approval of the compact. That action requires 8 legislative members on this committee to vote in favor of that action, and it must be 4 senators and 4 representatives in order to take that action. Conversely, the committee could vote to recommend not approving the compact, in which case, again, a resolution approving the compact is introduced in both chambers, but this time the committee report is recommending to reject the resolution, if that is the committee's vote. That action also requires 8 legislative votes in the affirmative, 4 senators, 4 representatives. And finally, the committee could vote to forward the resolution approving the compact to the legislature without recommendation, in which case the committee report has no recommendation on what the legislature should do with it. That action only requires 5 votes of the legislative members of this committee. And then I will point out that neither the governor's representative nor the attorney general's representative can vote on any of those 3 actions when you're forwarding the compact to the full legislature. You do also have in your seats copies of the 2 relevant statutes on directions for reviewing the compact under 46-2302 and the vote requirements on those particular actions under 46-2303. And with that, Mr. Chairman, I'd be happy to answer any questions.
Thank you. Are there any questions? Seeing none, thank you very much. Next, we'll move on to the Office of Attorney General and Dan Burrows. Dan?
Thank you, Mr. Chairman, fellow members of the committee. Appreciate you giving me the time to talk here. As the Attorney General's designee, we come at this with a slightly different angle from the governor's office, just because of the way that the statute makes our position. The statute makes the Attorney General the counsel to the governor during the course of negotiating the compact, but then counsel to the committee in the course of considering the compact. But I do want to note that we work closely with the governor and her representatives to get through negotiations on this, at least as long as we have been in office, the current administration, since January 9th. There were a lot of legal issues that were here. I think it's worthwhile mentioning some of those just because the issue of timing has been brought up. One of the legal issues that's been sort of mentioned up there is the pending federal court case law relating to whether this so-called hub and spoke model, but basically the idea that you could place a bet on your phone while not standing on tribal lands, and that bet be, as a matter of law, considered to occur on tribal lands. It's a federal law issue. There's only one case on it that I'm aware of. It's a federal district court case that found that that is not allowable under the Internet Gaming Regulatory Act as part of a compact, but is currently on appeal to the DC Circuit. And so we're trying to work out what that means for us in a situation where the governor is trying to negotiate a compact based on the law as it exists now. The other issue, though, that hasn't been mentioned, I think is worth mentioning because timing was mentioned, is the fact that until approximately 2 weeks ago, no one was allowed to even, under the law, submit a compact that contained these remote wagering provisions. The legislature just passed that bill, I believe, 2 weeks ago. And so insofar as there are timing concerns, there was no way this negotiation could even take place until as of 2 weeks ago. And that was because of strictures that the legislature put on the governor in negotiating the contract, not any sort of delay that the Attorney General's office or that the governor's office was artificially imposing on this. Since that was passed, we have had significant meetings, including a lengthy meeting with the tribes and the governor's representatives at the Attorney General's office to try and hammer out a situation where, at least as a matter of legal advice, the Attorney General's office could be comfortable with this. I think we've done that. There are several issues with remote wagering related to the Indian Gaming Regulatory Act. They are, like I said, unsettled, but attorneys deal with unsettled matters all the time, and you've got to try and figure out a way to advise your client the way through it. And I think the agreement that's been hammered out here mitigates a lot of the risks, in fact, most of the risks, in a way that the Attorney General's office is comfortable saying is a perfectly rational and reasonable way to work through it if the end goal is to get the tribes some involvement in sports wagering. And so from a legal perspective, which is the only way that we were approaching this, we didn't have a policy position here. We think that this compact nails that down sufficiently well that we feel comfortable about it as a matter of advising our clients, which is this committee now, to limit their litigation risk here. So I think it's about as good as you could possibly get given the end goal and given the current state of the law. I think it's worth mentioning as well the sort of looming issue in the background. It's been mentioned, the dispute over the tribal boundaries. The reason that's an issue is a Supreme Court case from a few years ago called McGirt versus Oklahoma. That case went to the Supreme Court essentially on a criminal law issue. But the underlying question was, what are the metes and bounds, the legal description of this particular Indian reservation in Oklahoma, considering the fact that the entire city of Tulsa, Oklahoma, for example, was within that legal description. And the Supreme Court said, look, Congress has to speak clearly to disestablish a reservation. Congress has that power to do so, but has not done so here. Now, the result in Oklahoma has been, the immediate result is essentially tribal members can only be prosecuted by the feds or by the tribes and not by the state of Oklahoma and Oklahoma. There's been a lot of predicted chaos from that I have not actually seen evidence of playing out. But nonetheless, that's sort of in the background here, that regardless of whether that argument is meritorious as applied to the prairie band, it is a very complicated and thorny issue that is, I think, as a matter of being careful, a reasonable and prudent decision was made to set that to the side and deal with what we could obviously and easily deal with, which was the sports wagering. So that's what's here. The Attorney General has been involved in this. We are comfortable as a legal matter that this mitigates legal risk as much as possible. I can take specific questions. If I can't answer them, I have a colleague from my office, Dennis DePew, who's also involved in the negotiations, who could perhaps supplement my answers.
Thank you for that explanation. It was very clear. On the McGirt, Oklahoma case, that passed, was the vote 5-4? It was close.
I don't remember what the final vote was. I remember it was a Gorsuch decision, but it certainly was not the typical sort of ideological or partisan divide between the sides. There were so-called liberal and so-called conservative justices on both sides of that issue.
2020. So were there a lot of similarities for the request in this compact that fell within that court case?
I don't know that I can speak to the precise similarities or whether their claims are meritorious, particularly because it could potentially wind up in litigation at some point. I think what I can say is McGirt is sort of a looming presence in the background that everybody is aware of, and that probably it is prudent to let that issue lie.
So that summary can probably be read online, couldn't it, the decision summary?
Sure, the decision is it's publicly published.
Thank you, Mr. Chair.
Any other questions? Thank you very much. We move on to conferee testimony, and two of our conferees have spoken. I'm going to give them another word. Will, if you have anything to add? Will, did you have something else to add?
Thank you, Mr. Chairman. I don't know that I have anything else to add. I guess the only thing I would note is that because we had to pass legislation to deal with one of the provisions in Simple 84, that also is why we're here at this point in time as opposed to earlier in session. That was a particular sticking point for us in trying to figure out how to wrangle with that language between the AG's office and Prairie Band Potawatomi Nation. So that, that meant that we had to get a bill passed quickly, which we did, and we appreciate all the support on that, and then allowed us to get here very quickly in a matter of 2 weeks. So,
Thank you.
thank you.
Yes, Representative Hayward.
Thank you, Mr. Chair. Can you remind us about that bill number? What that bill number was?
Ooh, is it 2058?
HB 2058?
Yep, Senate substitute. Yep.
Okay.
Any other discussion? Seeing none. Dan, did you have anything else to add?
I don't, Mr. Chairman. Thank you.
Thank you. Our next conferee would be the outside counsel from Prairie Band Potawatomi Nation, and Russ Barner. Welcome to committee.
Yeah. Good morning. Thank you, Chairman. Thank you, committee members, for the opportunity to present testimony. As you noted, my name is Russ Bren. I'm outside counsel for Prairie Band Potawatomi Nation. If I may indulge the committee, I'd like to recognize some dignitaries in the room. We have with us today the entire governing body of the nation, Chairman Joseph Rupnick, Vice Chair Zach Pomami, Treasurer Wade Pomami, Secretary Lori Melchior, the members William Evans, Tony Wawiotin, and Raphael Wawasik.
Welcome to the committee. Thank you.
I'll do my best to be brief this morning for you. I know you've got a lot of work to do today. I did want to just highlight a couple of things from the conversations that have taken place this morning and just make a couple of quick points. One, we are here discussing an amendment to the compact, the gaming compact between the state of Kansas and the nation. That is a government-to-government negotiation between sovereigns pursuant to federal law. We're not in any way discussing gaming pursuant to the Expanded Lottery Act today. So those are different creatures. As such, I did want, there were a couple questions asked about revenue sharing, things like that. So as a matter of federal law, the state cannot ask for revenue sharing under a gaming compact except for specific circumstances, which are impossible under the current legal framework in the state of Kansas. So I'll just leave it at that. I will also note that just like the state of Kansas owns its gaming and it has managers, the nation owns its gaming and has an entity which manages that gaming for it. State takes a share of the hold, if you will. The nation takes a share. The nation's share is 100% of the hold. It takes all those revenues and applies them to governmental purposes: bridges, roads, healthcare, education. The list goes on and on and on. And to that point, then, the economic impact of the nation is such that the employees of the nation and its various operations make it one of the largest employers in Northeast Kansas, with the attendant economic impact throughout the state, including with things like income taxes, benefits of infrastructure that are available to everyone in the state of Kansas. I will note that substantially all the nation's interest points were addressed to its satisfaction ultimately in this amendment. Next point, there's some discussion of the expanded, or the broader, the reservation boundaries, if you will. I will note that pursuant to McGirt, it's fairly clear from the Supreme Court that that is a function of the United States Congress. It's not something to be negotiated between the state and the nation. And so that's really why. And the nation wasn't requesting negotiations over that. We were trying to be good neighbors and let the nation reached out to leadership earlier this session in both houses to alert them that there's this issue. And similarly, we alerted the governor's office and the AG's office that this is existing, nothing to be addressed in the compact, but we just want everyone to be aware of that. And that's going to require a lot of conversation and work between the two governments in the future to work through those issues. I think the AG did an excellent job summarizing the Flagler decision out of Florida, and that's ultimately the compromise we came to. The nation would have loved to have said, Department of Interior has clearly indicated it supports these type of mechanisms in the past, and we would have loved to begin doing remote wagering from the get-go once the compact's approved by the Secretary of Interior. But we understood the rest of the state of Kansas, and we negotiated the language that's in the bill today, so that once the compact becomes effective, I think it leaves your question, Representative, the nation will be able to engage in brick and mortar wagering, as Will said. Will be engaged into limited remote wagering on its Indian lands as defined under federal law. And then only if the West Flagler decision is ultimately goes the way we believe it will go and is upheld if it's appealed to the Supreme Court, will the nation be able to do statewide remote wagering under the compact. I don't think I really need to address anything else, but I'm happy to stand for questions from the committee.
Thank you very much. Questions? Yes, Senator Haley.
Thank you for the review, and thank you, Mr. Chair, for recognizing me. I appreciate this. This may seem kind of off point, but you might help me to better understand. So does Prairie Band also vend alcohol? And I remember the cigarettes that are vended there.
Right.
You have those that are available on the reservation.
Yes. I'm sorry.
You do have those, right?
Yes, sir.
Is there any place other than on the reservation where you're able to vend those? In other words, are you able to sell cigarettes other than exactly on the tribal land, cigarettes or alcohol, other than at the actual site?
So those are two different legal frameworks. I'll address alcohol first, if I may. So alcohol, by federal statute, no one is able to vend or consume alcohol in the Indian country unless there is a tribal liquor ordinance that's approved by the federal government and the licensee complies with state law. So that's what you have at the Prairie Band Casino as one example, or at their Firekeeper Golf Course. They hold liquor licenses from the nation, issued pursuant to an ordinance that's been approved by the federal government, and they also hold drinking establishment license under Kansas law through the ABC. And so that's why the tweak in the compact is necessary, because after the compact was negotiated and they set vending hours for alcohol, the Kansas legislature relaxed those hours so that the drinking establishment licensees on the nation's lands were at a competitive disadvantage with other drinking establishments in the same county even. So that's that framework. For cigarettes, it's a little different. There was always discussion over who has jurisdiction over what activities take place. those activities were ultimately part of an even lengthier compact negotiation process in 2015 regarding tobacco, and that was initiated at the request of Governor Brownback at the time in order to permit the state to protect its revenues under the multi-state settlement agreement. The nation agreed to certain concessions, but also received certain concessions. And so as a result of that, the nation has agreed that it will license and regulate cigarette sales on its lands, and that it will not license to outsiders those retail activities. The nation also is able to license its wholesalers. And in fact, the nation does own a wholesaler, and that wholesaler engages in activities on the reservation pursuant to nation law, but it also engages activities from time to time outside the nation's boundaries in accordance with whichever state it happens to be operating at that time.
You see where I'm going, Mr. Chair. So revenue can be generated for the nation off your lands.
It is possible.
It is, I mean, well, through tobacco. You're able
Yes.
to vend a product that can be consumed.
Well, in order to vend off the lands, they would have to comply with the state's regulatory framework to be a retailer, and they don't have any entities that do that. They do have an entity that I'm not sure if they still do it, but at one time they did hold a wholesaler's license to vend in the state of Kansas.
And again, my concern now is this is something that someone will be able to do without ever going to your actual casino or being actually on your land. They'll be able to interact with this product, if you will. They'll be able to game from anywhere in the world.
Not anywhere in the world, only within the boundaries of the state of Kansas, because federal statute would clearly prohibit that.
Anywhere in the state of Kansas, though, but without ever having to go to or to purchase or to participate by being exactly on your property.
It is possible if remote wagering is found to be legal under federal law.
Okay. Thank you.
Any other questions? Seeing none, thank you very much.
Thank you.
We'll open up to committee discussion. Is there any discussion by the committee? Seeing none, I entertain a motion.
Thank you, Mr. Chair. I would make a motion to amend the Potawatomi ban, Prairie Ban, Potawatomi Nation, Kansas Gaming Compact.
Have a second? Second by Senator Holland. Any discussion? Okay, yes, Senator, or Representative Tidewater.
Okay, thank you, Mr. Chairman. So my colleague here is not at all wrong that for whatever reason, this is being rushed. And unfortunately, if we decided to take more time to look at this and make sure that it was done fairly for the nation, we put the nation at risk because we're gonna adjourn in the middle of all this, and then they won't have the ability to do gaming, sports gaming. And so I think I'll support this, but I would like to, if this committee is going to meet again, I'd like to, when we get back here next year, to make sure that this was done fairly, because the nation deserves it.
Thank you very much for that comment, and I fully agree with you. The issue is that we're going to, if this is successful coming out of here today, we will take it up this afternoon, and then it'll be over to the House.
Correct. So we want to make sure that that gets done properly and that they can start down the road. But I think we need to take a serious look at this when we aren't rushed for one reason or another, to make sure that they get to do, it's their nation. They can do what they want, in my opinion. So thank you.
Thank you. Any other discussion? Yes.
Mr. Chairman, I just have a point of order. I think the motion could be interpreted a couple ways. I just want to confirm that the motion is to approve the proposed amendments to the gaming compact.
If I need to correct that, I will.
Thank you.
Thank you.
You want to withdraw and restate?
Okay, I withdraw my first motion. Okay, and now, Jason, do you have advice on how to make this exactly like we need it?
Mr. Chairman, I would just advise that the motion be to approve the proposed amendment to the Prairie Band Potawatomi Nation Kansas Gaming Compact and to introduce a resolution to that effect.
So moved.
Second? Second. Moved and seconded. Any other discussion? Seeing none, because of the rules that we do have, that we're under, we have to have 4 from the House and 4 from the Senate. So I'd like a roll call vote, please. If you can.
Senator Larry Alley.
Aye.
Senator Elaine Bowers. Senator David Haley. Senator Tom Holland. Senator Dan Kirshen. Representative John Alcala. Representative Will Carpenter. Representative Christina Haswood.
Aye.
Representative Fred Patton. And Representative Sean Tarwater.
Aye.
Results are unanimous.
Yes. Sorry.
Motion's approved. So with that, is there any other discussion or any other business before the council today? Seeing none, meeting's adjourned. Thank you very much.